Hi, my name is Jamie Pierce. I'm the General Counsel for the League of Oregon Cities. And in this video today, I'll be going over public meetings in Oregon, legal requirements, and best practices. Through this training, we're going to cover a new mandatory training requirement, definitions, legal requirements, virtual meetings, serial meetings, executive sessions, public participation, and finally, grievances and complaints. First, the mandatory training. New for public officials is a mandatory training that's required for governing bodies with a total expenditure of $1 million or more. This training needs to be taken once per term, and officials are required to maintain a record and then be able to truthfully certify completion if requested. LOC recommends keeping track of the date of the training, the presenter's name, and the location of the training. Second, we're going to start with definitions. The public meetings law intent is for government to be transparent. The Oregon form of government requires an informed public aware of deliberations and decisions of governing bodies and the information upon which such decisions are made. It is the intent of the public's meeting law that decisions of governing bodies are arrived at openly. As public officials that represent local government, the public has a right to know how we make our decisions and that we arrive at our decisions openly and transparently. First, what's a public meeting? Under the law, a meeting is defined as the convening of a governing body of a public body for which a quorum is required in order to make a decision or to deliberate toward a decision on any matter. We'll explore each of these underlying definitions thoroughly. A governing body is the members of any public body which consists of two or more members with the authority to make decisions or recommendations to a public body on policy or administration. What does this actually mean in real words? If you sit on your city council is the governing body for your city. A public body, in short, is the city. But the technical definition includes the state, any regional council, county, city, or district, or any municipal or public corporation, or any board, department, commission, council, bureau, committee, or subcommittee, or advisory group, or any other agency thereof. What's important to know as a city official is that your city, any council or subcommittees there are, is a public body. Again, types of bodies subject. These are decision-making bodies, such as your city council. Advisory bodies, such as any subcommittees or advisory committees your city may have. But this does not include purely fact-gathering bodies or any sort of committees or bodies that only advise individual public officials. What's a quorum? A quorum is defined as the minimum number of members of a governing body required to legally transact business. What does that mean? Well, most quorums for cities are defined in your city's charter. So if you don't know the quorum necessary to conduct business for your city, check your city charter. Most likely, the quorum is considered 50% of the membership plus one. So if your council consists of 7 council members, a quorum for your city is likely 4 members. If your city council consists of 5 members, a quorum in your situation is likely to be 3. But again, when in doubt, refer to your city's charter for the specific number required for your city. Convening. Convening means gathering in a physical location, using electronic, video, or telephonic technology to be able to communicate contemporaneously among participants, using serial electronic written communication among participants, or using an intermediary to communicate among participants. For example, you can convene without actually sitting in the same place at the same time. An example of this would be a Zoom meeting or a group telephone call-in. In addition, and we'll cover this later, you may have a situation where you convene via email or other written communication methods without even sending those communications at the same time. We'll address that later. Communication. A communication is the expression or transmission of information from one person to another through verbal, nonverbal, written, or electronic means. Nonverbal means includes gestures such as a thumbs up and a thumbs down, as well as sign language. So remember, when you're sitting at a council meeting, communication includes more than the words that you state. You have to be aware of the various nonverbal gestures you may or may not be making. Intermediary. An intermediary is a person who is used to facilitate communications among members of a governing body about a matter subject to deliberation or decision by the governing body, by sharing information received from a manner or members of the governing body with other members of the governing body. The term intermediary can include a member of the governing body. So, for example, council members could relay messages through the mayor, and that mayor would be considered an intermediary. Serial electronic written communication. A series of successive or sequential communications among members of a governing body using written electronic means, including emails, text, social media, or other electronic applications that communicate the written word. This is an example of where you can convene without sitting at the same place or sending messages at the same time. Essentially, this covers a serial meeting. A serial meeting is essentially an unlawful executive session, and here's how one hypothetically could take place. The mayor talks to the council president about an item of city business. That's less than a quorum. That's only 2 members. And for the purposes of this example, let's assume a quorum is 4. Then the mayor talks to Councilor Rodriguez about the same item of city business. There have only now been 3 members of the council who have talked about this matter of city business. Because this is not a quorum, a public meeting has not occurred. However, if the council president or Councilor Rodriguez or the mayor then email Councilor Thomas or Councilor O'Shea or any other member of council about the same item of business, 4 members, aka a quorum, have now discussed a matter of city business. This is an example of a serial meeting and not permitted. Serial meetings can occur in person. They can occur via telephone calls. They can occur via video conferencing, or other electronic video applications. They can occur via written communications, including text, emails, and others, or with the use of 1 or more intermediaries to convey information among members and other means of conveying information. Deliberation. Deliberation means the discussion or communication that is part of the decision-making process. Decision. A decision is any determination, action, vote, or final disposition upon a motion, proposal, resolution, order, ordinance, or measure on which a vote of the governing body is required, at any meeting at which a quorum is present. Another way to state this definition is that anytime a motion is being made and being voted upon, the council is making a decision. The decision-making process includes when the governing body engages in to make a decision, such as identifying or selecting the nature of the decision to be made, gathering information related to a decision to be made, identifying and assessing alternatives, weighing information, and making a decision. So in addition to having a motion and making a vote on the motion, the decision-making process also includes the identifying of the topic at hand, gathering of information and research to address the topic at hand, and any other part of the process in which the governing body would arrive at the making of a motion and then the vote. Discussion. This is the consideration or debate of a matter. Types of public meetings. You have your regular meetings. These are things such as your regularly scheduled public city council meetings. Your city council meetings may occur once a month, every 2 weeks, or once a week, or any other time specified by your local policies. Public meetings also include special meetings. These are meetings outside of the regularly scheduled meetings that may be scheduled ad hoc or when necessary. Emergency meetings are still considered public meetings. Executive sessions. We'll talk about the special provisions related to executive sessions in a further slide, but they are still considered public meetings. And finally, workshops and work sessions are also types of public meetings. What are not public meetings? On-site inspections of projects or programs, provided the members of the governing body do not engage in deliberations or decisions on matters that could reasonably be foreseen to come before the governing body. The attendance of members of a governing body at any national, regional, or state association to which the public body or the members who belong, provided the members of the governing body do not engage in deliberations or decisions on matters that could reasonably be foreseen to come before the governing body. Something that would be considered under that provision would be attendance at an LOC conference. And finally, social gatherings are not public meetings. Additional matters that are not public meetings: communications between or among members of a governing body, including communications of a quorum of members that are purely factual or educational in nature and that convey no deliberation or decision on any matter that might reasonably come before the governing body. Communications that are not related to any matter that, at any time, could reasonably be foreseen to come before the governing body for deliberation and decision, or non-substantive in nature, such as communication relating to scheduling, leaves of absence, or similar matters. There are additional matters listed under ORS 192-690. So, if something is a public meeting, what are the legal requirements? First off, they must be open to the public. There are location requirements. There are notice requirements, accessibility requirements, and minute-taking requirements. Let's explore these further. All public meetings must be open to the public. A quorum of a governing body may not meet in private for the purposes of deciding on or deliberating towards a decision on any matter except as otherwise specified or exempted by law. The location. Meetings of the governing body must be held within the geographic boundaries of the area over which the public body has jurisdiction, at the public body's administrative headquarters, or at the nearest practical location, and they must be held in a location accessible to persons with disabilities. Some exceptions to location requirements include training sessions in which no deliberations towards a decision are involved, joint meetings of governing bodies or a governing body and Oregon Indian tribal officials, and actual emergencies necessitating immediate action. No discrimination is allowed. A governing body may not hold a meeting at any place where discrimination on the basis of race, color, creed, sex, sexual orientation, gender identity, national origin, age, or disability is practiced. Public meetings cannot meet in a place inaccessible to persons with disabilities and cannot fail to make a good faith effort to have an interpreter provided at a regular scheduled meeting when requested at least 48 hours in advance. There are new remote access requirements. To the extent reasonably possible, public bodies must make all meetings, excluding executive sessions, accessible remotely through technological means and provide opportunity for members of the general public to remotely submit oral and written testimony if in-person oral and written testimony is allowed. It's important to note this only applies where reasonably possible. If for some reason it is not reasonably possible for your city to allow for remote access, you will not be out of compliance with the law. Notice requirements. Cities are required to post notice for their meetings, which are open to all members of the public to contain, at a minimum, the following requirements. the time, date, and location of the meeting, the electronic link or telephone access information, again for remote access, a list of principal subjects anticipated to be considered at the meeting, for example, the agenda. This requirement does not limit the ability to consider additional subjects. The name, telephone number, and email address of a person to contact to request an interpreter or any communication aids, or a notice that a sign language interpreter or other communication aids will be provided. Your local rules may provide additional requirements. Method of notice. Interested person lists, mailing lists, or other lists of persons or groups maintained by the governing body to provide notice or communications. Social media platforms normally utilized by the governing body for communications, or any other means reasonably calculated to provide actual notice to interested persons known to the governing body, are all examples of ways a governing body may provide notice. Notice to the media. A governing body satisfies the media notice requirement by providing notice to those media representatives who have requested notice, either in the method requested by the media representatives or by other means reasonably calculated to provide actual notice to the media representatives. Timing. For regular meetings, as much notice as reasonably possible, but no less than 48 hours in advance. For special meetings, cities are required to provide at least 24 hours notice in advance. For emergency meetings, such notice as is appropriate to the circumstances. An attempt to contact media and other interested persons must be made. Minutes must describe the emergency justifying less than 24 hours notice and the reason why the meeting could not be delayed for another 24 hours. When we talk about emergency meetings, what we mean are true emergencies that must be addressed in less than 24 hours time. Minutes. By state law, minutes must include a true reflection of the matters discussed at the meeting and the views of the participants, and the following: all members of the governing body present, all motions, proposals, resolutions, orders, ordinances, and measures proposed and their disposition, the results of all votes and the votes of each member by name, if there are less than 25 members, which includes all city councils, the substance of any discussion on any matter, and a reference to any document discussed at the meeting. All minutes or recordings must be available to the public within reasonable time after the meeting. Now note, there is no requirement that minutes be written. An audio recording or a video recording of the meeting will suffice. However, your local rules may require a written minute reflection. Voting requirements. All official actions by public vote must be recorded. Votes must be recorded by name, and secret ballots are prohibited. If there are written ballots, they must include the name and the vote and be announced during the meeting. Virtual meetings. Meetings may be held entirely virtually, where board members, council members attend remotely and no physical location for members of the public attend. However, the city must make available to the public at least one place where, or at least one electronic means by which the public can listen to the communication at the time it occurs. A place provided may be a place where no member of the governing body of the public body is present. So for example, if your council members are all meeting via Zoom, a city meets virtual meeting requirements by providing a link in which the members of the public may view the meeting happening in real time. There does not need to be a physical location provided for members of the public to attend, so long as they have that link to attend virtually. Executive sessions. An executive session is any meeting or part of a meeting of a governing body which is closed to certain persons for deliberation on certain matters. It is important to note, executive sessions must be statutorily authorized. This means that a council may not hold an executive session for any reason it desires. There must be a statutory authority that addresses the specific topic in which the executive session is allowed. Notice for the executive session must list and cite that specific state law that authorizes the executive session. The news media has a right to be present, and final decisions are prohibited. The other legal requirements for all other public meetings are still applicable to executive sessions. Notice methods for executive sessions. Again, the same notice requirements for regular meetings apply. However, the additional requirements for executive session include the identity of the specific statutory citation and appropriate subsection and paragraph authorizing the executive session, as well as a general description of the statutory authorization. If part of a regular, special, or emergency meeting, the presiding officer shall identify in open session the specific statutory provision and appropriate subsection and paragraph authorizing the executive session, as well as the general description of the statutory authorization. Minutes. The same content is required of executive sessions that are required of regular meeting minutes. However, the city is not required to disclose if the disclosure of certain material is inconsistent with the purpose for which a meeting under the executive session provisions is authorized to be held. This means that minutes of executive sessions may be withheld from public disclosure. Virtual attendance at executive sessions. For executive sessions where the media are statutorily authorized to be present, if any person, including any member of the governing body, is attending the executive session by telephone, video, or other electronic means, the governing body shall provide members of the media with the same attendance option. This means that if any member of your council is attending an executive session virtually, members of the media must also be allowed to attend virtually as well. However, nothing in this subsection prevents the governing body from establishing reasonable security measures to ensure the media's attendance by telephone or other electronic means is conducted through a secure connection or method. I always recommend that if a city is providing a virtual attendance option, that they require in their attendance policies that members of the media name who they are and keep their video on. Who is a member of the media? While the state law does not provide clear guidance, we can look to the Attorney General's opinion on who is a member of the media. The Attorney General has opined that representatives of the news media for purposes of the executive session provisions include news gathering representatives who have a formal affiliation with an institutional news medium. A news media entity is institutional if it is formally organized for the purpose of gathering and disseminating news. As discussed below, however, the proliferation of technologies for disseminating information can make it difficult to identify which entities are institutional news media. If your city is having an executive session, how do you begin and end an executive session? Prior to beginning, you must announce the statutory authorization to hold the executive session. If you are having a standalone executive session, the announcement must be made in a properly issued meeting notice. If the executive session is combined with a regular public meeting, the announcement must be made during the portion of the meeting that is open to the public. After the executive session concludes, the city must use a reasonable means to give notice that the meeting is again in public session. So what are the reasons in which a city may hold executive sessions? The first is to consider the employment of a public officer, employee, or staff member. You may not hold an executive session, however, to fill a vacancy of an elected office, or for public committees, commissions, or advisory groups. You cannot use an executive session to consider general employment practices, and you cannot use an executive session to discuss salary. If a city is choosing to use an executive session to hire their chief executive officer, such as a city manager, a couple of things must first be done. First, the position must be publicly advertised. The city must then hold a publicly adopted hiring process that is conducted in a public meeting. During that public meeting, opportunity for public to provide input must occur. After those items are completed, then the city may hold an executive session to consider the employment of their chief executive officer. Another reason to hold an executive session is to conduct employee evaluations, only if the employee does not request an open hearing. So, if a city council would like to hold an executive session to conduct an employee evaluation, they must first give that subject employee the opportunity to request that that meeting be held in public rather than executive session. On the same note, a city may hold an executive session to consider dismissal or discipline of, or to hear complaints or charges brought against a public officer, employee, staff member, or individual agent, again, unless that person requests an open meeting. A city may hold an executive session to conduct labor negotiations or discuss labor negotiations with their negotiator. They may hold an executive session to discuss real estate transactions with a negotiator. The city may hold executive sessions for security purposes, such as to review or approve programs relating to security of telecommunications, data transmissions, power storage, hazardous material transport, to consider matters relating to safety of the governing body and of public body staff and volunteers, and the security of public body facilities and meeting spaces, and to consider matters relating to cybersecurity infrastructure and responses to cybersecurity threats. You do not have to hold a public meeting to tell the bad guys how to infiltrate your city and its systems. Other reasons to hold an executive session: to consider information or records that are exempt by law from public inspection, to consider with your attorney regarding current litigation or litigation likely to be filed, to conduct trade negotiations where the city is competing with governing bodies in other states. I do want to make a note about consulting with your city attorney. You may only consult with your city attorney under a specific executive session provision if the city is under current litigation or litigation is likely to be filed. So when can the city candidly speak to their city attorney for advice in situations where the city is not under current litigation or not likely to be under litigation? In that situation, the city would hold the executive session under the provisions to consider information or records that are exempt by law from public inspection. Public meeting and executive session violations. First, who oversees the public meeting laws? The Oregon Government Ethics Commission, or OGEC for short, now has authority over public meeting laws. Any person may request an advisory opinion or written or oral staff advice from the commission for actual or hypothetical situations involving executive sessions. The Oregon Government Ethics Commission can also provide guidance, advice, and opinions on matters relating to public meetings law. If a city has questions about whether they are complying with public meetings law, I recommend that they reach out to the Oregon Government Ethics Commission for a request for opinion or advice on the matter at hand. If the public body does not timely respond to a complainant's grievance, or if the complainant is not satisfied with the public body's written response, a complainant may file a complaint with the Oregon Government Ethics Commission. So for example, If anybody believes that the City Council violated the public meetings law in any way, that person may file a grievance with the city. The Commission may then investigate public meeting violation complaints for executive sessions. So, if a member of the public or any person believes that the City Council held an improper executive session, again, they may file a complaint and the Commission may investigate. If the Commission finds that the governing body violated the public meetings law, the Commission may impose civil penalties not to exceed $1,000. A civil penalty under this provision is a personal liability of each member of the governing body on whom the penalty is imposed. This cannot be paid for by the public body. This means that penalties imposed are personal in nature to the officials involved in that improper meeting. It is unlawful for the city to cover those penalties on behalf of its members. Website information. It's important for cities to have information on their website about the person and contact information to whom a grievance may be submitted, and the hours during which in-person grievances will be accepted. Absent these, a grievance can be filed with the Chief Administrative Officer, such as the City Manager, or to the Mayor. If there's no website, the city must publish notice in the same manner as meeting notices, in which this contact information may be found. There are two complaint methods in which a person may file a grievance against a public body when they believe the public meetings law have been violated. We will go through each of these separately. The first part, or process, is a grievance that can be filed in writing with the public body within 30 days of the alleged violation. This is construed as a complaint against all members of the governing body. The city must acknowledge and respond to both the person and the commission via email within 21 calendar days, and the city may either deny the allegations, admit allegations, deny the violation, or admit allegations, admit violation, and cure the violation. The city must then file a copy of the grievance and response to the commission. The city must accept grievances filed by in-person delivery during regular business hours, by first-class mail, or by email. The city may also accept grievances by any other means. After a grievance is filed, an individual must then file the complaint with the Oregon Government Ethics Commission. A grievance and response from the city is a condition for filing a complaint with the commission. The commission will dismiss a complaint if there is no grievance. A complainant is required to submit to the commission documentation of the complainant's actions taken under the statute. This includes steps taken to notify the city of the grievance and allowing the city to respond and fix the problem. The commission will dismiss any complaint filed that does not satisfy the requirements of the law. Who is liable for an Oregon Public Meetings Law violation? A complaint alleging violations of public meetings law that is filed with the commission under the state statutes will be construed as a complaint against all members of the governing body, and cases will be opened for each member of the governing body. When a complaint involves the members of a governing body, the commission will consolidate at the preliminary hearing and the investigative phase unless a governing body member objects. Individual determinations will be made for each member of the governing body. Penalties. Again, a civil penalty up to $1,000 for each member of the council for violations of the public meetings law is on the table. No civil penalty will be assessed if the council was acting at the advice of legal counsel, but a letter of education from the commission may be possible. A complaint that is dismissed for failing to comply with requirements is a procedural dismissal only. the dismissal does not prevent the Commission from taking up the matter on its own motion if it has authority to do so, or considering a new complaint based upon the same conduct. If at any time the Commission has reason to believe that there has been a violation of the state public meetings law, the Commission may proceed on its own motion as if the Commission had received a complaint. Outside of violations submitted to the Oregon Government Ethics Commission, a person aggrieved may file a lawsuit in circuit court. Any person affected by a decision of a governing body may commence a suit in circuit court where the public body ordinarily meets. This must be filed within 60 days of the alleged violation. If the court finds the violation is due to willful misconduct, the members shall be jointly and severally liable. The court may order such equitable relief if it deems appropriate. This includes reasonable attorney fees. A decision made during an improperly held public meeting is voidable. The governing body may reinstate the decision in a properly held meeting. Next, we'll talk about public participation. Can the public participate in meetings? The state public meetings law only requires public attendance. Public participation is not required, with two exceptions, such as land use hearings and budget hearings. However, your local documents may require both public attendance and public participation. Look at your charter, look at your ordinances, and look at your rules of procedure to determine where attendance and participation may be required. If a city allows public participation, it must also allow the same participation via virtual means where held. So for example, if the city allows in-person testimony, it must also allow oral testimony by electronic or virtual means if a virtual meeting is being held. In addition, if written testimony is being allowed in person, written testimony must also be allowed electronically. If your city allows public participation, such as public comment, it's important to know that public comment is protected speech. Speech is protected under both the federal Constitution and the Oregon State Constitution. The Oregon Constitution is more restrictive on speech than the federal level. This means that public bodies may not base or restrict speech based on its content. It must be content neutral. However, cities are still allowed to place reasonable time, place, and manner restrictions on the public's participation. What does this look like? Cities may dictate the time for public comment. For example, some cities allow public comment at the beginning of their council meetings. Some cities allow public comment after every agenda item. Some cities allow public comment at the end of the meeting, and some cities do a combination of all of those above. Cities may dictate the location where public comment is made. For example, most cities have a table or place to stand in which to address the council during public comment time. Cities may limit the topic of the comment, but be careful. An example of where this may be permissible is if your city has rules or guidance about public comment after each agenda item. A reasonable restriction would be that the public comment after each agenda item must be on the topic of that specific item. Cities may place time restrictions on public comment, such as length. For example, many cities have adopted 3-minute or 5-minute time limits for each speaker who addresses the council. And finally, we encourage all city councils to treat all speakers equally. This limits the ability of a member of the public to claim that they have been discriminated against based on the content of their speech. Can cities remove people from public meetings? In short, yes. However, actual disruption of the meeting is required. Offensive conduct is insufficient. What does this mean? A member of the public could be standing quietly in the back of the meeting room, but be making an offensive gesture. While this would be very distracting and certainly offensive, because the person is remaining quiet and is not actually preventing the council from conducting its business, this would not be actual disruption, and that person would not be able to be removed. Now, if that person was in the back of the room, but speaking loudly in which counselors could not hear one another, in which other members of the public could not hear one another, and that person refused to be quiet, then that may be considered actual disruption. How about arresting those who disrupt a public meeting? Again, yes. However, make sure it's law enforcement who determines if disorderly conduct crime elements are met. Individuals cannot disturb lawful assemblies like a city council meeting. But again, I really encourage city councils to rely on their law enforcement officials to determine if these elements have been met and to not physically remove someone themselves or cite someone for arrest unless they are a law enforcement official. Can we suspend people from attending future meetings? In short, probably not. However, if there is a true public safety concern or threat, it may be possible for a member of the public to be suspended from a future meeting. If you believe this may apply in your situation, please contact your city attorney and contact City County Insurance Services prior to suspending that person. Here are some best practices on how to make your public meetings run more smoothly. First, establish and follow procedures. Cities are encouraged to adopt rules of procedure for their council meetings. In addition, we recommend consistently enforcing these rules of procedure. These rules should apply to all the electeds, to the staff members, and to members of the public. It's advisable to have an agenda-setting policy. Know who can set the agenda and what that process looks like. And finally, cities should adopt public comment procedures, such as time, place, and location in which members of the public may comment. And it's important to advertise and inform the public about what these procedures are. Examples of public comment procedures. The chair or mayor begins the public comment period by reading the council rules related to public comment. The city may utilize sign-in sheets for those interested in addressing the council. During the public comment period, council members should listen during the public comment and should not engage during the public comment period. We recommend council members sit and listen and not have a back and forth dialogue with the members of the public. However, if councilors have questions from the public comment, the council may direct staff to further investigate into the issue. An example would be a member of the public bringing up a concern to the council. Rather than the council trying to solve that problem at that time, it would be advisable for the mayor to ask for the city manager to receive that person's contact information in which the city manager or other staff can follow up at a later point. How else can we help make council meetings run smoothly? Read your meeting packet before the meeting. If you have questions about what is contained in the meeting packet, reach out to the appropriate staff member to give them a heads up about your question so that they can arrive at that meeting ready to answer your question. Read, review, and know your rules of procedure. Arrive on time. And if you are going to be late or absent, communicate that with the appropriate staff member. Be curious about your fellow council members' ideas. Listen and learn. Remember to focus on the policy discussion and not the person discussing it. Explain your reasoning for your opinions. And finally, don't use your cell phone on the dais. We all know we cannot multitask, and we will only be distracted if we are looking at our cell phone rather than actively listening to the meeting or to the comments taking place. The Oregon Government Ethics Commission, as I mentioned earlier, it has the oversight authority over public meetings law. Their website is on the screen in front of you, as well as their phone number and email address. I encourage those with questions to always reach out to the Commission for advice and guidance. Thank you again for listening about public meetings law and best practices. The League of Oregon Cities is always available to answer any questions you may have.